Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Sex Crime Defense Lawyers, Chicago, Illinois. If you're facing sex crime charges in Chicago, Illinois, you need experienced legal representation immediately. Allegations involving sex offenses are among the most serious criminal accusations under Illinois law, carrying severe felony penalties that can include prison time, mandatory sex offender registration, and long-term consequences to your reputation, career, and personal relationships. At Combs Waterkotte, our Chicago sex crime defense lawyers understand how overwhelming and stressful sex offense accusations can be. Whether you've been arrested, accused, or are under investigation for a sex-related offense, our criminal lawyers will work aggressively to protect your rights and build the strongest defense possible for your case. Call 3-125-00-HELP to begin fighting back against your charges today. Sex Crime Defense Lawyers in Chicago, serving all of Cook County, Illinois. Sex crime charges in Chicago and throughout Cook County can carry devastating consequences. A conviction may result in years behind bars, steep fines, mandatory registration as a sex offender, and permanent damage to your personal and professional reputation. When so much is at stake, you need a criminal defense team that understands how to challenge the prosecution's case and protect your future. At Combs Waterkotte, our sex crime defense lawyers have decades of combined experience defending clients accused of serious sexual offenses throughout Cook County. We understand that sex crime allegations often involve complicated personal circumstances, misunderstandings, false accusations, or weak evidence. That's why we approach every case with a detailed, strategic defense tailored to the facts of your situation. From the moment you hire our firm, we begin conducting a thorough investigation into the allegations against you. Our legal team will scrutinize witness statements, analyze digital and forensic evidence, identify inconsistencies in the prosecution's case, and fight aggressively to get your charges reduced or dismissed whenever possible. If your case goes to trial, we'll be prepared to defend you every step of the way. Throughout your case, we'll even work with you on a customized payment plan to ensure you can afford the best sex crime defense possible. If you've been arrested, charged, or are under investigation for a sex offense in Chicago or anywhere in Cook County, contact Combs Waterkotte today at 3-125-00-HELP or reach out to us online for a free, confidential consultation. The sooner you secure legal representation, the better your chances of achieving a favorable outcome in your case. Types of sex crimes we defend against in Chicago, Illinois. Under Illinois law, there are several sex offenses with which a person may be charged in Chicago or Cook County. Some offenses are more common than others, though, so it helps list Illinois' sex offenses in specific categories. Some of the most common Chicago sex crimes our firm helps defend against are sexual assault and sexual abuse offenses, child sexual abuse offenses, prostitution offenses, sexual assault and sexual abuse offenses in Chicago. Sexual assault and abuse crimes in Chicago and Cook County are what people generally think of when referring to rape, a word/offense that has actually been written out of the Illinois Criminal Code. Combs Waterkotte defends against many sexual assault and abuse crimes throughout the Chicago area, including criminal sexual assault, 720 ILCS 5/11-1.20, using force or the threat of force to sexually penetrate a non-consenting victim. Aggravated criminal sexual assault 720 ILCS 5/11-1.30, committing criminal sexual against a protected victim, using a weapon, or while drugging a victim. Predatory criminal sexual assault of a child 720 ILCS 5/11-1.40, sexually contacting or penetrating a victim under the age of 13. Criminal sexual abuse 720 ILCS 5/11-1.50, sexually contacts a non-consenting victim using force or the threat of force. Aggravated criminal sexual abuse 720 ILCS 5/11-1.60, committing criminal sexual abuse against a protected victim while drugging a victim or using a deadly weapon. Child sexual abuse offenses in Chicago. Child sex abuse crimes in Cook County are usually referred to as statutory rape or child molestation. There are quite a few of these offenses on the books in Illinois, but some of the most common we defend against are indecent solicitation of a child 720 ILCS 5/11-6, knowingly soliciting a child to perform sexual penetration or sexual conduct with the intent to commit sexual assault. Solicitation to meet a child 720 ILCS 5/11-6.6, using a phone or the internet to make plans to meet up with a child for illegal reasons. Sexual exploitation of a child 720 ILCS 5/11-9.1, exposes themselves or engages in a sexual act in front of a child or asks a child to record a sexual act. Child pornography 720 ILCS 5/11-20.1, creating, possessing, or distributing images or videos of explicit sexual acts involving a minor. Grooming 720 ILCS 5/11-25, using in-person or electronic communications to lure or entice a child into committing a sexual act. Traveling to meet a child 720 ILCS 5/11-26, traveling to, within, or from Illinois for the purpose of engaging in a sex act with a minor. Prostitution offenses in Chicago. Prostitution is illegal in Chicago, Cook County, and throughout the state of Illinois. There are a few specific prostitution-related offenses defined under Illinois law, but some of the most common prostitution charges Combs Waterkotte defends against are prostitution, 720 ILCS 5/11-14, knowingly performing, offering, or agreeing to perform sexual acts in exchange for money or other valuables. Solicitation of a sexual act, 720 ILCS 5/11-14.1, offering payment or gifts to someone other than your spouse for sexual activity. Promoting prostitution, 720 ILCS 5/11-14.3, knowingly helping someone engage in or making money from prostitution, an offense formerly known as pimping. Patronizing a person engaged in the sex trade, 720 ILCS 5/11-18, engaging in sexual activity with someone in exchange for money or visiting a brothel with the plan to have sex. Sex crimes penalties in Chicago, Illinois. The vast majority of sex crimes in Chicago, Illinois are felony offenses. Felonies have much steeper sentencing guidelines than misdemeanors, and the felony charge one faces for a sex offense in Chicago depends on the statute they violated and whether or not any sentence enhancement factors were at play. The possible prison sentences for felony sex offense charges in Chicago and Cook County Illinois are as follows. Class X felony sex crimes, 6 to 30 years in prison, 30 to 60 years for an extended term. Class 1 felony sex crimes, 4 to 15 years in prison, 15 to 30 years for an extended term. Class 2 felony sex crimes, 3 to 7 years in prison, 7 to 14 years for an extended term. Class 3 felony sex crimes, 2 to 5 years in prison, 5 to 10 years for an extended term. Class 4 felony sex crimes, 1 to 3 years in prison, 3 to 6 years for an extended term. Here are the possible felony charges an individual may face in Chicago for sexual assault and sexual abuse crimes. Criminal sexual assault. Class X felony. Class 1 felony. Aggravated criminal sexual assault. Class X felony. Predatory criminal sexual assault of a child. Class X felony. Criminal sexual abuse. Class 2 felony. Class 4 felony. Aggravated criminal sexual abuse. Class 1 felony. Class 2 felony. And here are the possible felony charges an individual may face in Chicago for child sexual abuse crimes. Indecent solicitation of a child. Class 1 felony. Class 2 felony. Felony. Class 3 felony. Class 4 felony. Solicitation to meet a child, Class 4 felony. Sexual exploitation of a child, Class 4 felony. Child pornography, Class X felony. Class 1 felony, Class 2 felony. Felony, Class 3 felony. Grooming, Class 4 felony. Traveling to meet a child, Class 3 felony. And here are the possible felony charges an individual may face in Chicago for prostitution crimes. Prostitution. Class 4 felony. Solicitation of a sexual act. Class 4 felony. Promoting prostitution. Class 3 felony. Class 4 felony. Patronizing a sex worker. Class 3 felony. Class 4 felony. Sex crimes in Chicago and the Illinois Sex Offender Registry. The Illinois Sex Offender Registration Act, SORA, 730 ILCS 150/1, requires that many individuals convicted of sex offenses in the Chicago and Cook County are registered with law enforcement for several years, and sometimes their entire life. Registering as a sex offender can affect where a person may live, work, or travel, and even whether or not they're allowed to enter certain public locations. Depending on the sex crime for which they're convicted, a Chicago resident may be categorized as any of the following under Illinois law, affecting how long they must remain on the Illinois Sex Offender Registry. Sex offender. Child pornography. Indecent solicitation of a child. Sexual exploitation of a child. Criminal sexual assault. Aggravated criminal sexual assault. Criminal sexual abuse. Aggravated criminal sexual abuse. Sexual predator. Commit a sex crime against a victim under the age of 18. Are convicted of predatory criminal sexual assault of a child. A person convicted of aggravated criminal sexual assault. Sexually dangerous person. Suffers from a mental disorder that has existed for at least 1 year. Demonstrates criminal tendencies toward sex offenses. Is predisposed to commit acts of sexual assault or sexual molestation of children. Sexually violent person. Criminal sexual assault. Aggravated criminal sexual assault. Predatory criminal sexual assault of a child. Aggravated criminal sexual abuse. Indecent solicitation of a child. Offenses that fall into the category of rape or indecent liberties with a child. Here are the typical amounts of time for which one must remain registered as a sex offender in Chicago or Cook County based on the crime for which they were convicted. Criminal sexual assault. Statute 720 ILCS 5/11-1.20. Registration, duration, typically lifetime. Aggravated criminal sexual assault. Statute 720 ILCS 5/11-1.30. Registration, duration, lifetime. Predatory criminal sexual assault of a child. Statute 720 ILCS 5/11-1.40. Registration, duration, lifetime. Criminal sexual abuse. Statute 720 ILCS 5/11-1.50. Registration, duration. Typically 10 years, possibly lifetime. Aggravated criminal sexual abuse. Statute 720 ILCS 5/11-1.60. Registration, duration. Typically lifetime if victim is a minor. Indecent solicitation of a child. Statute 720 ILCS 5/11-6. Registration, duration. Typically lifetime. Solicitation to meet a child. Statute 720 ILCS 5/11-6.6. Registration, duration. Typically 10 years, possibly lifetime. Sexual exploitation of a child. Statute 720 ILCS 5/11-9.1. Registration, duration, lifetime. Child pornography. Statute 720 ILCS 5/11-20.1. Registration, duration, 0 years for first offense, lifetime for repeat offenses. Grooming. Statute 720 ILCS 5/11-25. Registration, duration, 10 years for first offense, lifetime for repeat offenses. Traveling to meet a child. Statute 720 ILCS 5/11-26. Registration, duration, 10 years for first offense, lifetime for repeat offenses. Unless they involve offenses against a minor child under the age of 18, prostitution convictions generally do not require sex offender registration under Illinois law. How to get off the sex offender registry in Chicago, Illinois. Illinois law does provide a pathway for some Chicago sex offenders to be removed from the registry eventually. The removal process differs a bit from case to case, but generally, individuals seeking removal from the registry should follow these steps. Step 1. Determine whether the registration period has expired. Under 730 IILCS 150/7, many people convicted of a sex offense must register for 10 years following completion of their sentence, probation, parole, or mandatory supervised release. Before asking to be removed, though, a registrant must determine whether they are subject to 10-year or lifetime registration, when their registration clock legally began, whether any registration violations extended the registration period. The Illinois State Police maintain a statewide sex offender registry that can provide information regarding a person's registration classification and status. Step 2. Complete all registration obligations. 730 ILCS 150/3 and 730 ILCS 150/6 are the portions of the Illinois Sex Offender Registration Act that cover registration requirements during a convicted individual's duration as a registered sex offender. Common requirements include registering with local law enforcement, periodically verifying their registration information, reporting any address changes, reporting any employment or school information, complying with all statutory reporting deadlines. Step 3. Petition for relief, if eligible. After completing their sex offender registration period and obligations, some individuals may seek removal from the Sex Offender Registry. 730 ILCS 150/3-5 covers an individual's right to petition for termination of the obligation to register as a sex offender. In missed cases, a person must file a petition in the county in which they live. After submitting this petition, the court may consider any of the following when making their decision: the severity of the petitioner's underlying sex offense, the petitioner's criminal history, whether or not the petitioner complied with their registration requirements, any potential evidence of rehabilitation, whether or not public safety concerns regarding the petitioner exist. Remember that removal from the Illinois Sex Offender Registry is never guaranteed. In some situations, prosecutors and law enforcement agencies may receive notice of the petition and have an opportunity to object to it. Step 4. Obtain a court order terminating registration. If the court accepts the petition, they may enter an order terminating the obligation for the petitioner to register as a sex offender. After that, the Illinois State Police will update the register records. Be aware, though, that even after removal from the public registry, some criminal records may still remain publicly accessible through court or background check databases. Can lifetime sex offender registration be removed in Chicago, Illinois? Individuals who require lifetime registration will find it significantly more difficult to seek removal from the registry. Offenders classified as sexual predators, sexually violent persons, or sexually dangerous persons often remain subject to lifetime registration under Illinois law. However, eligibility for removal can depend on the exact offense, the offender's conviction history, and whether the person qualifies under any statutory exceptions. Because the removal process can involve complex statutory requirements, court filings, and interactions with law enforcement agencies, many individuals seek legal representation when attempting to terminate Illinois sex offender registration obligations. Sex crime defense strategies we use to fight your charges in Chicago. Sex crimes in Chicago, Illinois come with the very real possibility of long prison sentences and lengthy registration periods on the Illinois Sex Offender Registry. As such, it's vital to hire a criminal defense lawyer if you've been charged with a sex crime in Illinois. At Combs Waterkotte, we've helped many Chicago and Cook County residents navigate their sex offense cases. We've developed several criminal defense strategies that have proven successful in securing acquittals, sentence reductions, and dismissals in these cases. Consent. Consent may serve as a defense in some Chicago sex crime cases involving allegations between adults, particularly criminal sexual assault or criminal sexual abuse charges. Your defense lawyer may argue that the sexual activity was voluntary and mutually agreed upon, directly contradicting the prosecution's allegations of force, coercion, or lack of consent. Text messages, social media communications, witness testimony, and prior interactions between the parties can become critical evidence in these instances. However, consent is generally not a valid defense in cases involving minors or individuals with mental impairments. False allegations and motives to fabricate claims. Some Chicago, Illinois sex crime accusations arise from personal disputes, custody battles, breakups, or a desire for retaliation. In these situations, The defense may focus on exposing inconsistencies in the accuser's statements or identifying any motives they may have to fabricate allegations. This strategy can be especially important in criminal sexual assault, grooming, or child abuse investigations where physical evidence may be limited. In these cases, defense attorneys usually review text messages, social media records, prior reports, and witness testimony to challenge the credibility of the allegations and create reasonable doubt. Entrapment in Internet sting operations. Entrapment defenses may apply in online solicitation or child exploitation investigations involving undercover police officers. In some Chicago and Cook County cases involving solicitation to meet a child, grooming, or traveling to meet a child charges, law enforcement officers sometimes pose as minors online and initiate conversations with suspects. A defense attorney can argue that investigators improperly pressured, persuaded, or induced someone into committing a sex crime that they otherwise would not have committed. Reviewing chat logs and investigative tactics can become critical when determining whether police crossed constitutional boundaries during the investigation. Alibi defense. An alibi defense argues that the accused could not have committed the alleged sex crime because they were somewhere else when it occurred. In many Chicago sex crime cases, surveillance footage, cell phone location data, work records, receipts, travel records, and witness testimony can help to establish the defendant's whereabouts. An alibi defense can be particularly effective in criminal sexual assault or public indecency cases where the alleged offender's identity is disputed. By demonstrating that the defendant was not present when the alleged offense occurred, the defense may create substantial reasonable doubt around the case. Lack of intent. Some Chicago, Illinois sex crimes require prosecutors to prove a defendant acted knowingly or intentionally. A lack of intent defense argues that the accused did not have the mental state legally required to commit the offense. This strategy may arise in child pornography or revenge porn cases where someone allegedly possessed or shared illegal material unknowingly or accidentally. For example, a defendant may claim they were unaware that certain files existed on a shared device or did not intentionally distribute sexually explicit images online. Challenging intent can undermine a critical element of the prosecution's entire case. Insufficient or unreliable evidence. In Chicago, sex crime allegations often involve highly emotional accusations but limited physical evidence. Defense attorneys may challenge unreliable witness testimony, inconsistent statements, flawed forensic testing, or weak digital evidence. This strategy is especially important in older allegations or cases that lack corroborating evidence. In criminal sexual abuse or indecent solicitation prosecutions, your defense team may argue that investigators failed to preserve evidence properly or relied too heavily on assumptions rather than verifiable facts. Exposing evidentiary weaknesses can help create reasonable doubt and protect individuals against wrongful convictions. Fourth Amendment violations. In most Illinois sex crime cases, police gather electronic evidence from phones, computers, cloud accounts, or private residences. A Fourth Amendment defense challenges any evidence that may have been obtained through unlawful searches or seizures without a valid warrant or probable cause. This strategy frequently appears in child pornography, revenge porn, and Internet exploitation cases where digital evidence forms the foundation of the prosecution's case. If police violated constitutional protections during their investigation, a court may suppress the evidence, which can significantly weaken the prosecution's ability to convict. Fifth Amendment and Miranda rights violations. Statements made during police questioning usually play a major role in Cook County sex crime prosecutions. Defense attorneys may challenge confessions or incriminating statements obtained after investigators ignored a suspect's constitutional rights. If police failed to provide Miranda warnings during interrogations or continued their questioning after a suspect invoked their right to remain silent or have a lawyer present, the defense may seek to suppress those statements under the Fifth Amendment. This strategy can be very important in criminal sexual assault, solicitation, and child pornography investigations where prosecutors are relying heavily on admissions made during interrogations. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.